All right, good morning and welcome to a session of oral arguments before the 5th District Court of Appeal. I'm Judge Edwards. We have Judge Eisnagel and Judge Traver as the other panelists. And we have now before us case 2917, Jamal Omar Ruiz versus the state of Florida. With regard to oral argument, we typically reserve 5 minutes rebuttal for the appellant. If you'd like anything different, just tell us. And you can assume we're familiar with the facts and law as set forth in the record and in the briefs, but you may proceed, Mr. Appellant.
Good morning. May it please the court. My name is Robert Adams. I am counsel for appellant Mr. Ruiz. Your Honor, the case before you comes because appellant is asking the court to find that the trial court erred in denying Mr. Appellant's dispositive motion to suppress. The motion to suppress raised the issue of whether the plain smell or plain view of cannabis, in Mr. Ruiz's case, it was plain smell, rate is sufficient on its own to constitute probable cause for a detention and search of his vehicle. The issue of cannabis providing probable cause has historically been resolved by saying cannabis alone is probable cause. The smell of cannabis is unique. It is so telltale that an officer can easily identify it, whether it's in raw or burnt form, and provides distinct probable cause that the person is in possession of cannabis. However, that was at a time when the possession of cannabis was always categorically illegal. That is no longer the case. The Florida legislature has changed the cannabis laws so to add the hemp program, which is statute 581.217, and to also add the medical use statute, statute 381.986, and specifically amended the medical use statute to include the ability to possess prescription cannabis in a form for smoking. These additions come also with a change to the definition of cannabis under the controlled substances section 893.02 subsection 3, changing the definition of cannabis to specifically exclude cannabis that is in compliance with the medical use statute, meaning it's possessed, purchased, manufactured in compliance with that statute, or cannabis that qualifies as hemp under the definition in 581.217 section 2D that provides a definition of hemp as cannabis plant that contains a THC concentration of 0.3% or less. The changes to the definition we can liken to the changes to the definition of concealed carry of a firearm, which was addressed by the first DCA and the Kilburn case, where the first DCA held that since the definition of the crime has changed to specifically state that the crime is committed when a person who does not have a concealed carry permit is possessing a firearm while concealed, that person has committed the crime. And the addition of that change to the definition, making it a requirement that the person not have the CCW license, meant that law enforcement needed something in addition to just seeing the gun that was tucked into Mr. Kilburn's waist to decide.
What if the smell had been the smell, and I don't think that our record's clear on this point, but what if the testimony had been from the officer that, look, the smell was the smell of burnt cannabis? Is it ever legal to smoke marijuana while driving? And if the smell had been of burnt cannabis, would that change your argument?
There are a couple circumstances under which the smell of burnt cannabis would not be an indication of illegal activity. Generally speaking, under the medical use statute, it would not be legal for a person to smoke controlled cannabis, meaning cannabis with a THC above 0.3% in a vehicle while in use. However, the smell of burnt cannabis would be identical whether it is burnt cannabis with a THC concentration high enough to make the cannabis controlled, or if it was THC concentration 0.3% or lower, making it hemp. So if a person were burning hemp in their vehicle, that would produce the same smell and would not be unlawful. There's also the distinct possibility, because of the pungent nature of cannabis, that a person could smoke it, could burn it, could be around it burning, have the smell on them, and then proceed into a vehicle. And like
well, the probable cause doesn't require absolute certainty that a crime has been committed, right, counsel?
No, it does not. However, it does require a significant, or I believe the words were substantial, chance of criminal activity. And because the smell alone is going to be so common for unlawful, or for, lawful uses, that the smell alone provides no significant or substantial chance of criminal activity on its own. I don't believe that it, at this point, provides a reasonably prudent officer on its own with the ability to say this is criminal activity.
And regardless, I mean, that's not really the issue we have here, because I don't remember seeing any testimony that the smell was specifically of burnt cannabis, right? It was just the smell of cannabis, correct?
I believe there was an indication by Deputy Viner that it was burnt cannabis, because Deputy Viner did say that he was asking Mr. Ruiz, did you smoke? Now, that may have been the question he was asking.
Right.
But there was a conversation about actually burning cannabis at one point.
Well, he asked, do you smoke weed ever?
Correct.
I mean, that's not the same question.
No, but Mr. Ruiz's response at the time, my recollection was that he had smoked earlier that day. So at that point, the conversation, I believe, has turned into a conversation about burnt cannabis. But I don't believe there was a specific statement from Deputy Viner that he was specifically smelling burnt cannabis from inside the vehicle. But the conversation did turn to burnt cannabis at one point during the interaction.
There's also testimony from Officer Viner that suggested that he could smell the cannabis on your client. Taken in tandem, do you believe that provides support for the notion that he smelled like burnt cannabis?
I have no doubt that he smelled like burnt cannabis. The appellant never attempted to contest at the suppression hearing, nor in our briefs, that the smell of cannabis was present. This did not come down to an issue of officer credibility regarding the smell. The question only is whether that smell alone provides probable cause.
Doesn't the hemp statute specifically carve out as being illegal smoking hemp in a car?
I believe the medical use statute carves out that it cannot be used in a vehicle.
I think they both do.
Assuming
Assuming I'm not incorrect about that, then what could be the legal basis for smelling like burnt cannabis in a car under the probable cause standard?
Well, you can burn hemp without smoking it. You can also have burnt hemp around you, on you, before entering the vehicle. You can also have used medical marijuana before entering the vehicle because of the strong sense.
I think we all recognize that it's possible, right, to do all those things. And so the smell of burnt cannabis in the car might not be establish a crime with certainty. But Judge Traver's question was in the context of a probable cause analysis, right? So within the probable cause analysis, why wouldn't the smell of burnt cannabis create probable cause?
Because it does not indicate illegal activity on its own. The appellee seems to suggest that in its answer brief that we're attempting to discard the normal probable cause standard. Respectfully, I disagree. I think we're actually focusing more on the totality of the circumstances approach to probable cause. I think the smell alone is no longer enough on its own, and the officers need attenuating circumstances or accompanying circumstances. They need something that goes along with the smell or the sight of raw cannabis that would suggest that this is use or possession that meets the definition of the possession of controlled cannabis under the criminal statute.
Speaking of the totality of the circumstances, what were there other circumstances here that are undisputed that would have created a probable cause sort of under a tipsy coachman analysis?
That are undisputed? No. We have a dispute over a finding of fact that was included in Judge LeBlanc's written order that was not included in his oral ruling regarding.
Well, when I say undisputed, I mean either undisputed or, you know, or the trial judge found against you.
Taking the written order, Judge LeBlanc appears to have found that Mr. Ruiz made an admission that he smoked hemp, quote, to get high. However, a review of the body camera shows that that is clear error. The statement to get high was not even made by.
What about the wide turn and the headlights being off at night?
Those are commonplace traffic violations. I don't think they're indicative of.
They don't indicate potential impaired driving.
No, I think they indicate a person who is being negligent about their driving. Someone who may be in a well-lit area when they started driving, and then upon entering an unlit area, realized that their headlights were not on.
What about the wide turn?
A wide turn is frankly commonplace. Not to put myself on the spot, but I've done that myself. I don't think that's indicative. That's indicative of someone.
I'm not sure that's the probable cause analysis. Well, if I've done it myself, right?
Well, I think it's that a common sense person would be able to look at this and say, I believe reasonably that this is.
Counsel, I mean, I think any one of these things by itself might be different than when you add them all together. Do you agree?
Yes, I think that's the crux of the appellant's argument, is that the smell alone is not enough. It needs to be added with other things.
And when you add it to the wide turn that was observed, the fact that your client was driving at night without his headlights on, why can't we consider all of those things in combination in a tipsy coachman analysis?
We can, but I don't think that those things are indicative of criminal activity, not sufficient enough to make a reasonable person believe that this person is high, that this person is in possession of a controlled substance.
So your position is that we can engage in that totality of the circumstances analysis here on appeal, but your argument is that those things together just isn't enough.
Specific to Mr. Ruiz's case, we're arguing those circumstances, even in their totality, did not rise to probable cause.
What about the discussion that he came from? Was it Hacienda Boulevard, where the deputy had vast knowledge of illegal drug dealings? Is that something that tips it over the edge?
I don't believe it does. First, I would note that Judge LeBlanc did not find that was sufficient evidence to support that this was a high crime area. I don't believe that single conclusory assertion that he has familiar with various drug cases from that area is enough to deem it a high crime area without some sort of comparative analysis.
I mean, you know, when you read the trial judge's comments, it almost sounds like the trial judge rejected that argument.
I'm sorry, which argument?
The high crime area. It didn't sound to me like the trial judge necessarily made the finding that it was a high crime area. In fact, you could make the case that he intentionally avoided making the finding.
I believe his indication was that he was not making that finding specifically, because counsel was in the middle of arguing against finding that it was a high crime area. And his comments, at least from appellant's interpretation, appeared to indicate that he was saying that's okay, counsel, I agree with you, let's move on. And to try to move to the issue that Judge LeBlanc had stated in his oral ruling was the issue that he believed turned the matter of whether to deny or grant the motion, which was whether or not the smell alone provided probable cause. The lower court found that it was. Appellant obviously is contending that it does not.
I mean, counsel, so going to the video, right, which is maybe we haven't really hit on this. So you have the no headlights at night, wide right turn, then the smell of cannabis, potentially even maybe we could imply in there the smell of burnt cannabis. But then in the video, arguably, your client says in response to the officer's question, the officer says, why do you smoke? To get high? Arguably, your client says, yeah, like tobacco. I mean, arguably. So what do we, how does that contribute to the analysis on the totality of the circumstances, if at all?
I don't, well, firstly, I don't believe a person really gets high off of tobacco. I think the insinuation he's making is that he smoked it to look cool like tobacco.
Well, but that's not, but I mean, arguably, if we assume, if we take the position that your client was responding to the officer's question, the officer's question was, why do you smoke it? To get high? Question mark.
And his answer was that he smoked it.
His answer was, yeah, I like tobacco. So is it not possible to sort of view that conversation as your client responding to the officer's question about getting high?
I don't believe it was an indication that he was saying, yes, he was confirming he did it to get high. I believe he was doing it for the visual, which is accompanied by him doing this mimed act of putting the...
So it's your position that essentially he wasn't actually responding to the officer's question. He was actually continuing his response to, so why do you smoke it?
I believe he was responding to that portion of the question, asking him, why does he smoke it? It was a very conversational, rapid back and forth interaction.
I mean, they were almost talking over each other.
Deputy Viner was certainly talking over Mr. Ruiz, making it very difficult to hear what Mr. Ruiz was saying without turning the volume up on the body-worn camera video itself. But I don't believe his answer indicated clearly, at least, that he was saying that he smoked hemp to get high. There seemed to be an indication that he was saying he smoked hemp because it looked like smoking tobacco, which is not an indication of substance.
It sounded like before that he said, in response to why do you smoke it, it sounded like he said for the look.
Correct.
For the look. I mean, maybe to look cool or something.
Correct. Not for the intoxicating effect, but for the appearance. I'd like to yield the remainder of my time for rebuttal, if that's all right.
Actually, Mr. Adams, one more thing before you do that. If you could address on rebuttal for me the permissibility of smoking hemp in a car. The statutory site is 381, 986, 1JF, 1J5F, 381.986, 1J5F. I just wonder about whenever it could be permissible to ever smoke cannabis in a car or smell like you were smoking in a car. Thank you.
Thank you.
The good news or bad news, we'll give you a little extra time to make sure you can address Judge Traver's question. So, Ms. Davenport, if you need an extra minute, feel free to take it. So we'll go ahead with the state. Thank you.
Thank you. May it please the court. My name is Chris Davenport, and I represent the state of Florida in this case. First of all, I'll just start with the body cam footage. When you're evaluating that, I couldn't understand what the defendant was saying. The audio on that is not great. Very easy to hear the officer. It's not so easy to hear him. But the officer testified what happened. He was there. He testified at the hearing, and he said, I asked him why his car smelled like weed. He said he was smoking earlier, and he said, were you smoking marijuana or were you smoking hemp? And the defendant said, oh, hemp. And you can see that on the body camera. It was like, oh, yeah, hemp, that's the way to go here. And then the officer said, do you smoke it to get high? According to his testimony at the hearing, the defendant agreed with that statement. And then the officer—
I tried to find that in the record, and I looked at the citations provided in the brief. I just didn't see a clear indication in the testimony, right, to support what you're saying. Could you point me to the record page?
Sure.
Of the testimony.
He was never he couldn't remember word for word what their interaction was. But I
think that if you're going to rely on the video, the word for word might be important here, because they were talking over each other. I watched it. I could understand a lot of what the appellant was saying, but some of it I couldn't.
Right.
And it was entirely, I thought the deputy at trial said possibly in response to whether he said he smoked it to get high. Am I incorrect on that?
I remember him saying that he did, that he smoked it to get high, but he never remembered specifically why, specifically how that conversation went word for word. When I'm looking at the video, you can see this conversation started when he said, your car smells like weed. Why does it smell like weed? I think that's pretty clear on there. And the defendant said, I was smoking earlier. And then it gets a little, they're talking over each other. So it's harder to tell exactly what they said after that.
I watched the exchange 7 or 8 times. I'm sure that the other panel members watched it numerous times as well. I guess my question is, where does the officer actually testify that, yes, he told me that he was smoking to get high? Because I just couldn't find it.
Yeah, let's see. I unfortunately didn't mark that in the record. I didn't see that as an issue. Let's see.
Well, I mean, I think the problem is the video isn't in.
White, right?
The video isn't entirely clear, right?
The video's not super clear.
So
I know that the defendant never suggested, the defendant jumped on the officer's suggestion that it was hemp. The defendant never brought that up.
Well, counsel, I mean, I don't want you to spend all your time looking through the record. I mean, I'll look again. I'll just tell you, I specifically looked in the record for direct, clear testimony from the officer in this regard, and I didn't find it.
Okay.
But do you need it?
I don't believe we do need it, because I think what's crystal clear, even from the body camera footage, is when the officer said, why do you smoke it? He didn't say, because I have cancer. Or I have glaucoma, or, well, I'm smoking it with my medical marijuana license. If he had said
hemp, could he smoke hemp to look cool? Is that legal to do?
I'm not sure about that. Judge Traver indicated that in the hemp statute, that's not allowed. I know you can't smoke either form in a car.
Could he smoke it before he got in the car to look cool at a party?
He could smoke hemp. Either. Well, look, I'm not super experienced in this, but I don't believe that people smoke hemp. Based on what the officer's reaction to that was like, come on, dude, you're not smoking hemp to get
well, was there any testimony that people don't smoke hemp?
There was not, but again, this is a reasonable person comment.
Well, I mean, like you, I don't know. I don't have the experience either. So if there was no testimony, I'm just not sure how far that argument's going to get you.
There was no specific testimony exactly what hemp is used for, but when you look at the hemp statute, I mean, hemp is a fabric. People make it into CBD oil. There's certainly no testimony that they smoke it. I mean, I don't know why you would smoke something with no effect on you. I mean,
what
hemp
if you, to look cool. Counsel is to look
maybe
cool.
That's certainly possible.
I mean, I think that's what he initially said in the video, is for the look. Let me ask you this. He's driving at night without headlights.
Right.
He makes a wide right turn, right? None of that's contested.
Right.
Then the officer, once he pulls him over, the officer smells cannabis or hemp. And then has this kind of, at minimum, a strange conversation with the appellant, right? About what's going on. At minimum, a kind of an odd conversation. I mean, why is that not enough for probable cause? When you like, let's say that under tipsy coachman, we look through the totality of the circumstances. Why is that not enough for probable cause?
I think that is more than enough for probable cause. And we also have the fact that they ran his tag and they knew that he had a drug history.
They didn't know that until they were in the middle of the search, it looked like.
I think he testified that he knew that before the search.
But
before the stop. But
they informed him in the middle of the video.
Right.
And the trial judge rejected that argument because the trial judge noted that it was in the middle of the video.
Okay, that's fair. They knew he was on release. Well, I mean, that might have been in the middle of the search. I think there's enough just with the smell of cannabis. I think there have always been innocent explanations for the smell of cannabis, and an innocent explanation doesn't eliminate probable cause. It's a common sense probability of criminal activity.
What innocent explanation was there 10 years ago? What 15 years ago? What innocent explanation was there?
I was at a party and they were smoking and it got on my clothes. That's an innocent explanation for why it smells like pot. I mean, everybody knows that's a pungent smell that kind of sticks to you if you're near it.
What about now with unburnt or fresh? Is there an innocent explanation for it that's different?
I think 10 years ago, there probably was not. I
About-
can't think of one.
How about now?
But there is an innocent explanation now. Sure, it could be medical marijuana or it could be hemp.
So
There-
what about a situation, and I'm changing the facts of this, it might be more of an academic question. What about a situation in which it is unburnt in a car and you don't have the other indicia of probable cause that Judge Eisnagel was talking about? Does that automatically give you probable cause to search now based on the changes in the law?
Yes, I believe it does.
Can you
Because
explain that to me? Because what if you're a hemp farmer
if you're,
driving around in the middle of the day, and you've got a brake light or an expired tag?
then, it's the same as before. What if you were at a party where there was burnt marijuana on it? The law is clear that
my example, counsel, is specifically
for
unburnt.
fresh.
Fresh.
Again, it's analogous in that you can come up with an innocent explanation for this, but the question is whether or not there's a probability of criminal activity. Is this enough to go to a jury? Is this enough to arrest somebody? It's a probability, common sense.
You don't think that the changes in the law as passed by the legislature, you don't think that changes the probable cause analysis at all?
I think the fact that there is a potential for an innocent explanation doesn't make it not enough.
There's a whole lot more potential for an innocent explanation now than there was 15 years ago. You would agree with that?
I do agree with that. And I cited a lot of cases from other states where they were facing the same thing. They have legal hemp. Hemp is legal under federal law now. There's legal hemp, there's medical marijuana, and all of those cases, they say, it's probable cause. It's not beyond a reasonable doubt. And there's tons of cases that talk about just because you can conjure up an innocent explanation doesn't eliminate probable cause. That's not how that standard works. The police don't have to.
How do you reconcile that argument with the pill cases and the gun cases? Involving, you don't know if a pill's on a dashboard or in a console just by looking at it, whether it's legal or illegal. You don't know necessarily by looking at a concealed weapon whether or not that person has a concealed carry permit or not. In other words, the illegal nature of it is not immediately apparent. How is it different than those situations?
Well, for the gun case, first of all, there's a constitutional right to carry a gun. And in that Kilbourne opinion, they cite that. And I think it's an important factor in that is that.
Well, there's a constitutional right to have medical marijuana.
To have medical marijuana, but not all marijuana. Right. And is it medical marijuana? When you look at the medical marijuana statute, that's a very limiting statute. I mean, the regulations on that are very extensive. So even if I have a medical marijuana license, I can't carry a kilo of pot in my back seat. It's very limited. I can't go buy it on the street and then put it in my car. I have to buy it from a regulated provider. I have to use it and I have to have small quantities. I mean, it's very regulated. It's not like pot is legal now. You can't come to Florida and carry around a bag of pot. That's not how it works. It's very, very limited who can have it and in what circumstances. Again, with burnt marijuana, especially, you can't smoke it in your car. Again, there's possible innocent explanation. He was smoking it to look cool beforehand. He was at a party and it got on his clothes. There's always innocent explanations for these things.
Counsel, don't you think, Counsel, I hear your argument, and you're making a reasonable argument. The question becomes is, where do we fall on it? But so I don't fault you for making the argument, but wouldn't you agree that the more the legislature modifies these statutes and the more situations that the legislature says, cannabis is legal, and the more these statutes open up, the more difficult the probable cause analysis becomes for law enforcement?
I absolutely agree with that. It certainly opens a can of worms, yes.
So the analysis is more difficult now than it would have been 20 years ago, right?
I agree with that.
Okay.
And the analysis, if somehow recreational use of marijuana was legalized here, recreational use smoking marijuana was legalized, maybe that would be enough to tip it over where, gee, there's so many innocent explanations that it kind of overcomes, well, this could be criminal, which I
Well,
think
then it wouldn't be criminal at all if recreational use was completely legal, right? I mean,
well, it'd still be presumably criminal to carry around a kilo of it. I mean, I think in the states that have legalized recreational use, they still limit the amount that you can have.
okay.
Yeah, so I think, and then you're going to get into, gee, how strong was the smell? I mean, did it smell like a lot or a little? But that's
Well,
something.
counsel, let's focus on the sort of totality of the circumstances. Counsel says, look, a wide right turn, come on, that happens every day. Is what he said. I mean, and maybe it does, right? Why is the wide right turn, the headlights off at night? I mean, by the way, the headlights off at night, that can, I mean, just by itself, that's probably happened to everybody at some point, right? You're in a lit parking lot, you don't even realize your headlights are off or something, right? So by itself, so respond to counsel's argument that, look, all these things, if you look at them, they're not necessarily indicative of impaired driving.
Well, I think if you look at them individually and cut them all apart, that individually each thing is not probable cause to search, although again, we maintain that just the smell of cannabis gives you probable cause. But looking at the totality of the circumstances, you have to consider it all together. And when you put it all together with, the evening and his behavior, the officer testified he was nervous, that he immediately admitted he was smoking. I don't think it's probably unusual. We could agree to smoke hemp. Maybe it happens, but it certainly seems unusual from a common sense standpoint, especially when it was the officer who said, were you smoking hemp? And he said, yeah, that's what I was smoking. You consider his driving pattern, the time of day, the area, all of those things together. You have to apply the whole totality of the circumstances, not just any.
I think in the video, the officer even asked him why he appeared to be so nervous.
Yes, he did. Yeah. How do we judge their nervousness? We're not out on the street. We don't know what a typical reaction is. He looked nervous to me. He didn't look nervous to defense counsel, but it's the officer who sees these folks every day. I would just let me circle back around because I never really addressed the pills. I talked about the guns, but the pill cases. This would be if Florida legalized recreational marijuana in sufficient quantities and didn't really regulate it. I think that's when you'd get closer to these pill cases, because if I have a white pill in my car, it could be an aspirin, it could be a vitamin, it could be a prescription that I have a prescription for, or it could be, an illegal drug. The probability isn't there because pills are so rampant in our society that they're different from cannabis. At this point in our history, you have to have a medical marijuana license, which is not easy to get and it's highly regulated, or hemp, which I would submit isn't super prevalent. I mean, I think the variations of hemp are more prevalent. CBD oil is prevalent. There's hemp seeds and things being sold in the supermarket, but they don't smell, in my experience, like cannabis does. Raw hemp does. And there's certainly testimony that raw hemp smells the same as raw marijuana. But, in its refined form, I don't think there is that odd smell that kind of sticks out to people. So I would say that is how the pill cases are distinguished. Maybe in the future, if the legislature continues to take steps decriminalizing marijuana, that would be a different thing. But just the fact that there's medical marijuana, since it's so highly regulated, and hemp, which frankly, people probably aren't carrying around in a raw form. I think that still, the smell of cannabis is still enough to support a search, as it always has been, and as these courts in other states have found. I would also just note that the first DCA has addressed this in Johnson, and it was before smokable marijuana came about, but they did address the whole, there's medical marijuana and hemp. And they said, just to conclude, it's not unreasonable for an officer to conclude that there's a fair probability that someone driving around smelling of marijuana is acting unlawfully. And I think that's a great summary of our position. We would ask the court to follow the Johnson decision and apply it here, even though now we have smokable marijuana, medical marijuana. I think that decision is well reasoned, as are the decisions in other states that find that this is still, from a common sense, reasonable focus, considering all the law that says innocent explanations isn't enough to eliminate probable cause. I think given all of that, that this court should affirm the trial court's finding. If the court finds that's not enough, I think totality of the circumstances here, there is more than just the smell of cannabis. When you see it, how the defendant acted and the other circumstances of his driving and, it being at night and things like that, that's sufficient as well. I think there's enough evidence in the record to support the finding that's a high crime area. I think the trial judge was trying to see. He said, I'm basing this on the fact that there's a smell of cannabis. I think the trial courts want an answer to that. Is that enough? I think.
But counsel, I think the problem with I think there was substantial competent evidence that it was a high crime area. I think your problem there is the trial judge didn't make that finding.
He did not want to. He specifically said, I'm not finding any of these facts.
We can't really make that finding, right? I mean, that's not.
Well, I think there's an argument both ways on that. I mean, it's certainly sufficient in the record. If there's a conflict in that evidence, you could certainly remand and ask the court to make the finding based on the totality of circumstances, since his rationale at the hearing was, all I'm finding is hemp smells like marijuana. They're the same, but that's still enough for a search. And we agree with that. We think you should affirm that finding. But, in the written order, there's also more in the totality of the circumstances, why he was stopped and how he acted is obvious on the body cam. So even if just cannabis is not enough, we would submit that under the totality of the circumstances here it is. But again, I don't believe the law has changed to an extent that it's unreasonable to think that there might be criminal activity afoot when you smell cannabis in a car. I think that is still enough, even though there are some innocent explanations, more innocent explanations than there used to be. That doesn't defeat probable cause. So we would ask you to affirm the trial court's ruling. Thank you.
All right. Thank you. Mr. Adams, you're up.
Thank you, Your Honor. I apologize. Looking through my notes and my materials, I was unable to find the subsection that Judge Traber was referring to regarding the smoking of hemp in a vehicle. But assuming that Judge Traber is correct, that there is a subdivision of the hemp statute that says.
So let me clarify, Mr. Adams, and I apologize. I probably just garbled out the wrong subsection. It's in the medical marijuana statute. What it says is medical use does not include use in a vehicle except for low in THC cannabis, not in a form for smoking. So I guess my question is, what's the justification to smell like burnt cannabis in a car?
Your Honor, I believe the way to read that statute in tandem with the state hemp program statute 581.217 that specifically designates hemp as an uncontrolled substance would be to say that low THC under the medical use statute is referring to THC that constitutes low THC, but is still above 0.3%. So it would be an amount of cannabis that you would need a prescription to possess, but it doesn't, the THC concentration doesn't fall so low that it would constitute hemp. And in that case, you could possess it, but it cannot be in a form for smoking if you're going to use it in a vehicle. The issue, I think, with that is that that does not mean that the smell alone wouldn't be explained by hemp. And I say explained only in the sense that this court recognized in Sawyer that at a certain point, this isn't a question of ruling out innocent explanations. At a certain point, this is a question of meeting the bare definition of the offense. And since the definition of the offense in Sawyer was possessing a controlled substance and the officer couldn't readily identify it as a controlled substance, it wasn't immediately apparent under the plain view doctrine. He couldn't reach in and flip it over to look for those identifying marks. In the same sense here, if you can't identify it as the definition of cannabis in 892.03 subsection 3, sorry, 893.02 subsection 3, as cannabis that's not hemp and cannabis that is not possessed in compliance with the medical use statute, then you can't just assume, oh, that's what it is. You need the other circumstances to combine with the totality of the circumstances to reach the conclusion that this is likely criminal activity. This is substantial chance of criminal activity happening before the law enforcement officer. I don't believe that Deputy Viner had that at the point in which they decided to detain him so the other officers could start searching his vehicle. I think at that point, all they had was the smell, and the trial court's finding was the same.
Well, counsel, they had more than the smell. I mean, I understand your argument is that the additional factors that they had are still not enough, but they had more than the smell. Your client was driving at night without his headlights on and made a wide right turn at minimum. And then, as counsel reminded us, was also, there was testimony was also that he was acting in a nervous manner, and even the video, the officer said that. So there was a lot more here than just the smell.
I disagree. The appellant disagrees. Number one, I don't believe the nervousness that's demonstrated in the body-worn camera is any different from any other person who would get pulled over by a law enforcement officer.
That wasn't the officer's testimony. Was he was acting nervous?
Yes, that was his testimony. There's not a specific finding by the trial court that they.
And you have the wide right turn and the headlights off. I understand. I'm not asking you to concede that's enough. Obviously, I understand you don't think that's enough. I'm just saying that a minute ago you said all that we had here was the smell, and I'm just not sure that that's correct.
Oh, that's fair. Accurately speaking, the circumstances that were available to the officer at the time the search began was the smell, the traffic infractions, and the alleged nervousness. But the appellant would note that the trial court never made a factual determination that there was an unusual degree of nervousness demonstrated by Mr. Ruiz in the body-worn camera footage. There's not an indication that the trial court believed that the smell taken in company with the traffic violations were enough to reach probable cause. That specifically the trial court had indicated during the suppression hearing that it was the smell that did it. The smell.
But isn't it a de novo review? I mean, can't we engage in a tipsy coaching analysis, look at the undisputed factors or the factors that the trial court made findings on, and conduct our own probable cause analysis?
Well, the court has to conduct its own probable cause analysis de novo, but assuming and giving deference to the historical facts found by the trial court. And the historical facts found by the trial court did not involve any finding that those facts, the traffic infractions undeniably existed. The nervousness was not a factor that the court found. It was something that the trial court, as opposed to an appellate court, was uniquely in place to observe.
Your argument is that, look, the nervousness, we shouldn't factor that in because that the trial court needed to make a finding on that, whether or not the nervousness was the type that indicated criminal activity or just the type that normally happens when somebody gets pulled over.
If that's going to be attributed in the totality of the circumstances, in addition to the smell, in order to say the smell alone might not have reached probable cause, but with this nervousness did, yes, I believe it needed to be an included finding by the trial court, and the failure to do so leaves, I think, the appellate court with the simple question of whether or not the smell alone did it.
Plus the traffic infractions,
and the traffic
wide right turn. Yeah. Okay.
Correct.
All right. I think we're 3 minutes over, so I think that's plenty of time to make up for the extra questions. With that, I'd like to say the case was very well argued and well briefed, and you will get a decision. So thank you very much. We're in recess.